and let him do the introductions. Matthew?
Thank you very much, Wes. So welcome, everybody. My name is Matthew Erie. I'm an associate professor at the University of Oxford. I am one of the two co-chairs for the ASIL Asia Pacific Interest Group, joined by my colleague, Professor Gu Weixia of the Hong Kong University Faculty of Law, who will be speaking to you at the end of our session today. So a little bit of background on the Asia Pacific Interest Group. We are a group of lawyers, academics, policymakers, whose work focuses on international law, including public and private aspects as it pertains to the Asia Pacific region. We're inclusive and ecumenical in two senses, both professionally, including both people from the private sector, public sector, academia, as I mentioned, but also geographically. We define the region quite broadly to include Eurasia, South Asia, Central Asia, and the Pacific, as well as East Asia. Since 2020, we've been holding a number of webinars on COVID-19, national security law, ISDS reform. We've also started a newsletter on international law issues in the region that is actually edited by one of our panelists members today, Ms. Qian Bao. I'm very thankful to her. We are building a community of like-minded practitioners and academics. If you're interested in joining the Asia Pacific Interest Group, please check out the ASIL webpage, www.asil.org. For today's webinar, we're very fortunate to have a number of excellent experts to give us their thoughts about the RCEP. Our moderator is Professor Shiman Jiao of the University of International Business and Economics based in Beijing. I'm now going to turn it over to him. Professor Chi.
Thank you, Matthew, and warm welcome to all the participants and our speakers. As Matthew has said, it's our another one of a series of talks or webinars on cutting-edge issues relating to the Asia Pacific region. So today we're going to discuss the potential impacts of the RCEP RCEP on the Asian Pacific region, and we're very happy to have leading experts from this region. For the sake of time, I will not go through the bios of all these speakers, excellent ones. I just very briefly mention their names and their main affiliation so that you will know. So we have Ms. Qian Bao, an independent arbitrator of Arbitration Chambers of Hong Kong. We have Ms. Mary Elizabeth Chilia from Ministry of Trade and Industry of Singapore. And we have Professor Jae-Min Lee from Seoul National University of Korea. We have Ms. Mia Mikic from United Nations Economic and Social Commission for Asia and the Pacific, based in Bangkok, Thailand. And we have Professor Trinh Hai Yen from Diplomatic Academy of Vietnam. So we have a very brief discussion with regard to the topics, specific topics of each of the speakers. So without further ado, I would like to invite our first speaker, Mary Elizabeth Chile Lisi, to discuss the making of RCEP. So the floor is yours, Liz.
Thank you very much, and good morning, afternoon, or evening to the participants, depending which region you are coming from. Here in Singapore, it's about 9 p.m. So I apologize if I'm looking a bit tired. It's been a long day. So just to give you some background as to how RCEP evolved, way back in 2009, in the APEC community, we started talking about having a possible free trade area of the Asia Pacific. Arising from that, then the TPP negotiations were launched in 2010. So ASEAN was being courted at that time by China and by Japan to also expand on having the ASEAN integration. So instead of just the +1s, there was a lot of discussion as to have ASEAN +3 or ASEAN +6. The criteria in the end that ASEAN agreed on is that all existing +1 FTA partners, as long as you have completed 3 core chapters of the +1 FTA, then you'll be eligible to participate in what we now call RCEP, but that time it was known as the ASEAN +6 agreement. One of the reasons why I think many commentators think that TPP was US-led and therefore RCEP is China-led, is because China is the big heavyweight in terms of economic, although we have very well-established Australia, New Zealand, and Japan there, but commentators like to see it as the US versus China engagement, even via this race to who would do the free trade area of the Asia-Pacific model. So the understanding at APEC was that either you would then accede to TPP or you could then accede to RCEP. And what was left loose, because in RCEP you have India, who's not an APEC economy, was that whether the membership will be only confined to APEC economies or whether we would leave it loose. So in the end, people decided for RCEP to leave it loose, but TPP, they tried to say you must be an APEC economy first. So that's the genesis of how it started. So finally, after ASEAN agreed to do an ASEAN +6, and we waited for all the +1 agreements to be done. Ironically, the last one was ASEAN India. Then they launched the negotiations. They spent about 2 years, first of all, on trying to understand what sort of framework, how to go about doing it. And because it's ASEAN-led, then you also needed to work out the ASEAN centrality focus of the agreement. So the first 2 years, like most big regional FTAs, was spent with partners proposing ideas, chapters, and issues in chapters. So a lot of draft discussions were taking place. And then finally, about 2 years after that started, they agreed on what would be in RCEP in terms of the chapter scope. So actual negotiations of RCEP only really started in about 2013, 2014, once the framework was done. At the end of it, we finished the negotiations actually in 2019, but it took about a year before we could announce it officially, which was last year, because at that point in time, India was then uncertain whether they would remain in RCEP. There was a lot of theories as to why India was not clear whether they wanted to be in, but the fact of the matter, we have to respect their views. And so at the end of the day, despite a lot of persuasion by many of the RCEP members, especially ASEAN, India decided that they are not ready to join this sort of free trade agreement where they needed to open up a lot to who they thought were very competitive partners, and we may result in dilution of the Indian economy rather than expansion as the way the rest of us saw it. So India has decided to stay out for now, but we are still hoping that as Modi solidifies his, party power, because it also, the decision commentators feel was because of the way the elections turned out in 2019, where his majority was, narrowed down. So at the end of it, by now, RCEP, thankfully, has come signed. We are now waiting for ratification. We think it would take about a year or so. Of course, from the business perspective, the faster, the better. So how do you know when ratification is done? So the ratification requirement is that we don't need all 15 to have deposited their instrument of ratification. We only need 6 out of 10 ASEAN member states and 3 out of the 5 ASEAN FTA partners. And the ASEAN FTA partners will be China, Japan, Korea, Australia, New Zealand. Because, now it's just 3 out of 5. We don't have India. So that will kickstart. So a lot of work has already been done since the announcement last year by parties to start their domestic ratification. Of course, COVID for some countries then is a bit of a distraction, because you need to also make sure that your economy is running, because it's no use ratifying something and then your economy is not ready for it. So some are moving faster than others. We are trying very hard from the business perspective to try and get that 6 and 3 ready by the end of this year, so that by January next year, businesses can use RCEP. So what exactly is RCEP? We say it is currently is the largest FTA to date, thankfully, because we've got populous regions. So it covers 2.2 billion people and contributes to 30% of global GDP. So RCEP is the largest, mainly also because the US pulled out of TPP. So because the US pulled out of TPP, so that majority of GDP from 40% fell much down to about 20%. So RCEP, because China is with us in RCEP, we have strong powers like Japan and Korea, Australia, and of course my own country, Singapore, and the rest of ASEAN. So we comprise quite a hefty bit, and businesses therefore are very excited about what RCEP will bring to them. So just to give a brief overview, RCEP comprises 20 chapters. The key chapters, which I think lawyers especially will be more interested to look at, is not just the market access traditional chapters as well. I would encourage lawyers to pay a lot of attention to stronger and deeper chapters that we have on intellectual property, for example. If you look at the ASEAN +1 FTAs, hardly anyone has any mention or reference to IP rights. The only one is UNSFATA, which is the ASEAN, Australia, New Zealand. All the other +1s have been treating IP more of a cooperation, technical assistance sort of initiative. So if you look at the IP chapter in RCEP, you might be quite surprised. It is the most lengthy chapter. It covers everything. And for a lot of businesses, I think they can take assurance from the very strong enforcement provisions, which are then also to be found in RCEP. You also have more innovative ideas like protection of sound mark, scent mark, and thanks to the very strong, what I call following for K-drama, there's a lot also for digital, for all these collective agreements, things which are actually quite parallel to what you find in TPP. So, you know, RCEP has got a very strong chapter there. For rules of origin, because this is a regional agreement, it therefore opens up the sourcing and supply chain for all the businesses in the 15 countries. For the first time also, the origin criteria goes beyond the traditional regional value component. We have tariff shift, we have new process rules, which will also make it easier for businesses to navigate and take advantage. We are also aligned with all this digital, trying to move in towards a self-certification regime for RCEP. Some of the operational elements of this is still under discussion, but the understanding is that it would follow the ASEAN-wide self-certification scheme, which has also just recently entered into force. The other chapters of note, I think the lawyers might like to look at, is also the customs procedure, the SPS and the standards, which is also, again, very parallel to what is found in the TPP agreement. For the market access chapters itself, I would just say maybe don't hold your breath so much, because the 15 countries being adjacent to each other means that we all see each other as a competitive threat. When you see each other largely as a competitive threat, then your advances in the extent and amount of liberalization may not be as extensive as perhaps what we finally saw in TPP, because the TPP parties are not adjacent and therefore not competitive to each other in that way for the same market sector. So it's just something to bear in mind. The other unique feature I would say for RCEP is that they also start talking about e-commerce. For the first time, we also talk about competition. So I think if you look at the contents of RCEP and you compare it to what is already in existence for the ASEAN +1 FTAs, it is all these regulatory chapters, the SPS, TBT, IP, e-commerce, competition, that provide the strong regulatory framework compared to the normal ASEAN +1s, which has been very focused on market access liberalization. So you can see how they complement each other that way. The other point of note, I think that everybody will be wanting to know beyond ratification and entry into force, is what sort of open accession is there. So the provision in the accession side is that it shall be open for accession by any state or separate customs territory 18 months. So you can't join immediately. You have to wait 18 months after the date of entry into force of this agreement. So if the agreement enters into force in January next year, then it's only about July or something the following year that we can start to talk to potential acceding countries. There's no criteria at the moment as to, because when we did RCEP, the criteria for you to be a member of RCEP was that you must have completed an ASEAN +1 FTA. So if that is going to be a sort of criteria as well, then the only economy that will fulfill that is Hong Kong, because we have done ASEAN Hong Kong. So in discussions going on, we understand that they may not be so hard-fed to say it is only going to be, you must earn a +1, because we are looking at it, how to strengthen the whole regional network. And, you know, ASEAN is being courted by many other parties. You have EU, ASEAN, you have a lot of that. So it's up to each country then to assess whether the benefits, whether the provisions of RCEP are aligned with their own policy. We had a bit of a discussion about this with the EU, and we noted that maybe because RCEP doesn't have issues of interest to the EU, like environment chapter or labor chapter and things like that. And of course, the IP chapter makes it very difficult for you to protect GIs. Then it may be something the EU may not be enticed to join as an acceding country, and may still start an EU-ASEAN negotiations that has been discussed for a very long time. So I'll just stop there now, because my fellow panelists have got a lot more to say, and we can engage further during the Q&A. Thank you.
Thank you, Liz, for this perspective from the insiders. I would say very helpful. So next speaker, we would like to invite Mia. She will talk on the general impacts of the RCEP on the region from a social and economic perspective. So Mia, the floor is yours.
Thank you very much, and thank you, Liz, for making such a good introduction and overview of the sort of dynamics of putting RCEP in place, which is very useful, because indeed, you know, many critics of RCEP starts to look at it as a China-driven agreement, or the effort to enforce its own rules or hegemonic aspirations, etc., which I think is not helpful when we evaluate the potential of this agreement. And I would say that this agreement, and apologies, I will probably repeat some of the things that Liz said, but in a way to come to the point of the economic and potentially social impacts that it may have. So the fact that it is comprehensive is something that I think came as a surprise, because we normally have expected the standard, very you know, surface scratching only agreements, and so the richness of the cover of the scope of the agreement with its 20 chapters, and in particular, as Liz said, including some that ASEAN +1 do not have, intellectual property and e-commerce, as well as government procurement, I think, which is very useful, even if these do not go to the same depth as maybe TPP or some of the bilateral or European deals. It is a very good, I think, indication that the group on its own wanted to really create a region that would be able to grow and prosper and look into really the elements of integrating the economies. The other very important element that feeds into then economic impacts and potential of it is that this is for the first time that we have the region, which is, as Liz said, huge, that will operate under the single rule book of trade, right? So we have the fact that the 15 countries have agreed to have a single set of rules of origin with occasional, you know, bits and pieces. You cannot never have a perfect situation, right? But a single set of rules of origin that are extremely simple. That is another surprise of this agreement, that are extremely simple to actually meet from the position of a firm, and that lead towards a potential to really enhance regional supply chains and connectivity between the firms across the region. Now, of course, this is just one element, and it is definitely necessary, but not perhaps sufficient conditions, and there are many other things that need to be put in place for that. But it opens the possibility for a really expansion of the intra-regional cooperation among the 15. Now, of course, these single rules apply within the region, and so when they trade with the third parties, they will have to trade again separately with those third parties according to the rules that are done between themselves. But given the potential of this market, there is a prospect of enhancing this, particularly if the technical cooperation and investment will be matching these possibilities. The other very important element of this, and I come here from the with the UN hat, and it goes directly, Cliff, to what you were saying. Please talk about social impacts, not directly at the individual level, but if we are talking about delivering prosperity and growth for all, this agreement actually carries with itself low-income countries of ASEAN. So it actually brings together Myanmar and Cambodia and Laos to the same economic rule space as these others, but it doesn't force them to actually immediately enforce these rules, and it gives them flexibility in terms of the timelines. And what is important, which was always a problem with understanding, the special and differential treatment in the WTO and in some other agreements, whether it's useful or not, because those type of exceptions were excluding the commitments of countries towards liberalization. This agreement doesn't do that in general, and it requires the same commitments, but then it gives them the opportunity to have a longer terms of implementation, and many countries have actually in different ways already availed of that. Now, so these are the, and of course the uniqueness of this agreement, it is that it brings China, Republic of Korea, and Japan together. And this is the only agreement that allows these three giants to, in terms of trade, and in terms of technology and everything else that is at the frontier, that operates under these single rules. Now, when we look at and I'm not going to go in the separate chapters because there are experts here that will inform us much more about that. But I want to talk about how this then position the region towards economic benefits, and what does it mean for the rest of the world, right? So as Liz said, these economies are adjacent economies. They share borders, they share history, and they are very much competitive in terms of the very similar structure of their resources, and that lends itself to what they can produce competitively or not. And so one very obvious result of that is that the commitments in terms of the trade in farm products and fisheries are not very deep, right? Because these are the sectors that these economies can do well, right? And I think one of the reasons of the relatively low coverage of this is for that reason. Another is that this agreement doesn't have three areas which are normally associated with sophisticated comprehensive agreements, which is labor standards, environment standards, and sort of looking at reining in state-owned enterprises, right? And we can talk about that and talk about the meaning of state-owned enterprise and the subsidies and why regional agreement should or should not have it and why it should be on the WTO level. But this is again the reflection of what these countries can produce well, with what resources, is it cheap labor or not? And that's why these things probably were excluded, and also from the negotiation point of view, probably it will drag the negotiations into maybe a new decade. And so it was easier to just close the book on that. So when you look at what the impacts, economic impacts are expected, then economic modelers have difficult time, and there are research, there are many pieces already appearing on the estimation or simulation of the benefits of RCEP. I'm trying to synthesize these. Now, the simplest thing is to look at the static effects, right? So this is basically looking at how the trade creation and trade diversion will appear from this, and these in in relative sense are small, because, as Liz said, 83% of goods trade that are actually captured by these trade diversion and trade creation effects are already liberalized between ASEAN +1 agreements and by the multiple sort of bilateral agreements. So it's very difficult to come up with enormous static-based resource allocation effects of this effect, even taking into account huge size of this block, right? So the estimations go to the benefits of about $190 billion of this agreement, and then when you slice it to the actual economies, obviously in absolute numbers, China gets the biggest piece of the pie, about 80, if I remember correctly, $83 billion. Then Japan, then Korea, and then the rest. But this is in absolute, and it has to be like that, right? When you look at the relative gains, then it is the small countries like Malaysia and Thailand and Philippines that will benefit the most in terms of the addition to the GDP of their effects. The question always is, what does Singapore benefit? Because it has so many free trade agreements and from its own liberalization in goods cannot really benefit anymore. And this is the beauty of the whole thing. We can't really project what will be the ultimate effect of this agreement, because they will come from the dynamic side of changes, right? And so they will be the combined effect of the not trade liberalization in goods, but in terms of services, particularly digitally enabled services, in terms of investment, and in terms of these other regulatory issues that will simply put these countries at a different level of growth path, possibly, right? The issue is, so the new trade will be opened. Now, this is the only agreement that will give preferences to Japan in China market, right? So they will be even from the goods trade some of the benefits, but the most will come from these other areas, which unfortunately economists are not that clever to give you the number about. I mean, we can, but I would rather not, because someone may take it down and you're recording this, and then I will be declared a little bit silly if I go into these things. In terms of the expectations of these gains, the sooner we ratify this agreement and start implementing it, the better, because that would really then put in place these necessary forces, not only to look long term, but to see how this region can actually benefit from the current thinking about reshaping of the value chains, and how they can actually contain possible exodus of these value chains to somewhere else, and keep it still in the region, and not necessarily in China, but in some other parts of RCEP. So I would, obviously I can talk forever because I'm an economist, and I can use one hand and the other hand, but I'm not going to do that. I'm just going to summarize and say The RCEP is symbolically very important because it brings these three giants together, but it also brings the small, least developed countries that are normally bypassed in other agreements. It does have a great economic potential. It has a great potential to actually establish this region as the rule maker. And I think colleagues that will be talking about services and investment rules may go into that area and unpack the possibilities of this agreement to actually help stabilize the global trade system by actually putting some or keeping these rules stable. So let me stop here. I think I have talked too long, and I'll join discussion as it goes. Thank you so much.
Thank you. Thank you, Mia, for offering an economist, and probably I would also say as a social economist perspective, especially with regard to the development of the region. So next speaker will be Haiyan, and she will discuss the RCEP and the development of emerging regional economies and how RCEP would change the landscape of international investment law, particularly in this region. So, but before Haiyan, let me try to remind that we already having questions coming in. Some of the questions are directed to specific speakers. If you, I mean, any one of you would like to answer them, please pick the question. Otherwise, I would pick the question and direct to you after the whole presentations. So, Haiyan, please, the floor is yours. You have to unmute yourself. I'm sorry. Good.
Good evening from Vietnam to everyone. Thanks so much, Manju, for having invited me to take part in this very interesting, exciting webinar. What I would like to do is generally comment on the impacts of the investment protection provisions under Chapter 10 on investment, but not from the view of an insider, a negotiator, as my fellow panelists, but that of an academic. So what I would not touch upon is investment market access commitments in RCEP. My first observation is that RCEP investment chapter is an unfinished work because there is no self-contained enforcement or supervision mechanisms. Dispute settlement procedures from other international investment treaties cannot be imported by way of an MFN clause because RCEP Article 10.4 explicitly excludes that option. However, there is a provision, Article 10.18, which states that a work program will commence no later than 2 years after RCEP's entry into force. And such a work program will be concluded within the following 3 years for state parties to consider whether or not to amend RCEP to include investor-state dispute settlement, or basically dispute settlement procedures in RCEP. So anyway, what we have now is substantive investment protection in Chapter 10 without enforcement mechanism. In theory, the principle of pacta sunt servanda in public international law to ensure state compliance with their commitments can come into play, but then it is actually states talk. And the foreign investors have no official voice to challenge the implementation of Chapter 10. But this, to my mind, is only a theoretical issue. When we look at the two scenarios after the entry into force of the RCEP, the first scenario is the RCEP parties reach no agreement on dispute settlement provisions after the timeline for the work program expires. Then the consequence would be, I guess, my personal view, a document Chapter 10 Why? Because first, there would be no virtually no international forum for investors to challenge the implementation of this chapter. Second, investors protected by RCEP can always rely on other international protection schemes, which are created by other bilateral investment treaties and free trade agreements with investment provisions, which coexist with RCEP and which contains investor-state dispute settlement mechanism. Article 22 of the 20 paragraph 2 of the RCEP emphasizes that the state parties' intention for the agreement to coexist with their existing international agreements, which means there are multiple BITs and treaty with investment provisions. To be more specific, the ASEAN Free Trade Agreement with Australia, New Zealand, the agreements on investment with China, South Korea, all signed in 2009 and already entered into force. So with this scenario, the RCEP investment protection rules will not have much impact on the investment law landscape, or we will have no significant changes with RCEP. The second scenario is RCEP state parties will reach agreement on some kind of investor-state dispute settlement mechanisms, which would likely basically a reformed arbitration. My guess is based on what they have agreed before in their investment agreements. Then the situation still involves parallel application of those investment agreements. So if we ask the question of the impacts of RCEP standards of investment protection on international investment law landscape, my personal observation is that RCEP does not change the status quo. It basically follows verbatim what ASEAN member states have reached in their negotiation with external partners over a decade ago, I mean in 2009, which I mentioned before. And a notable example for that is a fair and equitable treatment clause, which is limited to a single state obligation not to deny justice in any legal or administrative proceedings. So this is the most frequently invoked clause in investor-state arbitration cases. Therefore, I think it makes the RCEP less appealing to foreign investors when they want to choose among the investment protection treaties applicable to them. Then for investors from RCEP state parties, except for 4 states, Cambodia, Laos, Myanmar, and Vietnam, those investors can import more favorable substantive standards of protection from other investment agreements pursuant to most favored nation clause. For investors from the 4 states, excluding the RCEP MFN clause, they can use other agreements, but not RCEP. So basically, I think it's a bit technical, but it concludes my brief remarks on the impacts of Chapter 10 on investment of the RCEP. Thank you for your attention, and I look forward to the discussion.
Thank you, Han Yan, for your insights on the RCEP and the international investment law landscape. So our next speaker, Professor Jamie Lee, will discuss RCEP trade and investment rules from, I believe, a more broader and probably a deeper perspective. So Jamie, please.
Cliff, thank you for the kind introduction. I prepared a couple of slides. If you permit, let me bring up those slides.
Sure, please.
Yeah,
go ahead.
And we'll share the slides. Here we go. Again, Clip, thank you. I'd like to thank Weisha and Matthew for organizing this important event. I just would like to echo what was mentioned by Liz, Mia, and Haiyan. And I believe this is an important stride. RCEP is an important stride in the difficult times. And 15 states agreement on this mega FTA is a very important development for these 15 states in this region, but also for the international trading regime generally as well. Let me briefly talk about investment rules. A little bit of them have been already mentioned by Haiyan, and I'd like to add a couple of issues with respect to the investment chapter. And the investment chapter is chapter 10 of the RCEP's 20 chapters. And as has been already mentioned by previous speakers, interestingly and importantly, and I should say critically, there are new rules included in RCEP, SMEs and the e-commerce and government procurement, etc. So these are all important development. And also, there are discussions on investment issues, and investment issues have been included in Chapter 10. Chapter 10 investment chapter largely follows, I think, the existing international investment agreements. So the provisions are largely following the existing provisions of the IIAs. One caveat though, there are only 18 articles in Chapter 10, which is a little bit short or brief, given the level of importance of RCEP as mega FTA. For instance, compared to the CPTPP or other important FTAs these days, only 18 provisions. Again, as mentioned by Haiyan, there is a reason. Because again, the most difficult or controversial issue, I would say, the investment arbitration. The whole issues have been deleted. I think it has been inevitable. Perhaps it was a prudent decision given the ongoing discussion in the international community about how to reform existing investment arbitration mechanism. So perhaps the 15 states had to make a decision that they would leave out the investment arbitration for the time being. And now let me get back to the ISDS issue shortly. And interestingly, general exceptions clause are applying to investment chapter. And security exceptions also apply to investment chapter. And interestingly, the security exceptions here is an expanded version. Expanded version, I mean more expanded than the RCEP-wide security exceptions. Let me get to the point soon as well. So now the Chapter 10 is subject to only state-to-state dispute settlement mechanism of Chapter 19 of the RCEP. And finally, one interesting point is also a particular provision on investment facilitation, which is an important topic at the WTO in the context of investment facilitation framework. So I think largely the Chapter 10 follows the existing norms of investment chapters of international investment agreements at the moment, but there are some key features here. This has been already explained by Haiyan. So this is 10.18, and this is the last provision of Chapter 10. As you can see, this is the flag for future negotiation. Within 2 years after entering into force, which is expected to be sometime next year, 2022, within 2 years, the 15 states are now going to resume the discussion on the ISDS. And that negotiation is supposed to be completed within 3 years after the commencement of the negotiation. So we are now looking at about 5 to 6 year window from now. It's very interesting to see how these 15 states will adopt or decide not to adopt entirely the ISDS mechanism in Chapter 10. So that's just something we can follow. Again, well, given the importance of investment arbitration in the investment chapter or BIT, it's rather interesting if I could put it that way, that the entire section of ISDS have been deleted for an investment chapter of the mega FTA, such mega FTA as RCEP. And now, this is the security exception, Article 10.15, security exception of the investment chapter, the typical security exception. And now, let me show you the security exception of 17.13. This is the RCEP-wide security exception. If you look at the red fonted provisions, they are omitted here. So basically, everything is the same except those red font words of Article 17.13, which is supposed to apply to entire RCEP agreement. It's interesting because here in Article 10.15, that 17.13 of security exception does not apply to investment chapter. As you can see here, it says, notwithstanding Article 7.13, the following will apply. So I would assume that because of the absence of these additional conditions for the invocation of security exceptions, one could arguably, one could argue that security exceptions in the investment chapter is wider or broader in terms of invoking the provision from the perspective of host state government. Maybe that's the decision, intentional decision of the 15 states. It's just something that we can flag for now, given the fact that there are differences between the two security exceptions here in the same agreement. Now, this is Article 10.17 on investment facilitation. I think this is relatively new. I think this is perhaps the first provision in an international investment agreement for investment facilitation specifically. This is the summary of the provision. Largely, it stipulates a best practice or the non-binding dispute mechanism or one-stop service or the ombudsman system. So I think this is the right direction. The only thing that we could contemplate on this particular provision is that it may be relevant to the current discussion at the WTO about investment facilitation framework. So the question mark is then, what is the relationship between the ongoing WTO's facilitation framework discussion and the particular provision on investment facilitation specifically included in the RCEP or future international investment agreements? That is something also we could look into going forward. Now, again, general exceptions are applicable to investment chapter as well. This is Article 17.12, which says that which includes Chapter 10 as a chapter to be subject to Article 14 of GATS. Now, finally, some highlights also. Interestingly, there's one provision in Chapter 17 relating to investment. Article 17.11 is entitled as Screening Regime and Dispute Settlement. And this provision is about how to deal with pre-investment measures of a host state. And the pre-investment measures are not subject to dispute settlement mechanism. Dispute settlement mechanism for the purpose of Article 17.11, of course, is not ISDS, because ISDS is not existing at the moment. So this provision means that pre-investment measures are not subject to Chapter 19's state-to-state dispute settlement mechanism. So on the one hand, the Chapter 10 substantively purports to protect pre-investment measures, but they are not subject to the dispute settlement mechanism of Chapter 19. So it seems to be a balancing act between the two competing interests, I think. And the second one, this is also mentioned a little bit by Haiyan, is that the complexity. This is not just about RCEP, but international investment agreements generally. The complexity multiplicity coexistence of IIAs. This is a big question mark. I just put here an example between Korea and Japan. Korea and Japan have a BIT in 2007, still in force. Two countries have TIT with Japan in 2012, still in force. And China have an FTA with an investment chapter still in force, and now RCEP. So the question mark is that how do we reconcile all these four different BITs? We'll find a way, I believe, but this is the complexity that raises a question mark for mega FTAs, particularly in this region, because we are all interrelated and integrated with the BIT's FTA, bilateral FTAs already. And now we have separate mega FTA covering the same issue. So that's one thing that we can contemplate again going forward. So because of this, possibly perhaps limited invocation of the chapter by foreign investors. I'm not quite sure, but possibly. Again, first of all, for the next 5 or 6 years, at the least, we will not have ISDS for the time being. So there's no mechanism for foreign investors to bring their claims according to Chapter 10 of RCEP. Impossible. Now, even if we succeed in introducing ISDS in the future, 7 or 8 years from now, the problem is, not the problem, but the unique traits is that the RCEP investment chapter 10 is subject to strong security exceptions and the strong general exceptions, which are not existing in other BITs and or other FTAs not necessarily existing in other BITs or FTAs among the 15 states. So from the perspective of foreign investors, they might prefer to rely upon existing BITs and existing FTA investment chapters to bring their claims, even with the new investment chapter with the new provisions on ISDS in the future. But nobody knows, but that's one thing that we could, again, discuss going forward. Finally, absence of secretariat seems to be a question mark, because again, Chapter 19 is very complex. Chapter 19 is very lengthy and very complex. And I think that any dispute arising under Chapter 10 and arising from any other chapter for that matter under RCEP will be subject to a very lengthy dispute settlement mechanism according to Chapter 19. I think perhaps a secretariat or something similar to secretariat might help 15 states handle these issues for the future, particularly so given the current paralysis at the WTO dispute settlement mechanism. And we are looking at 15 states encompassing a large areas of trade and investment. So there may be robust dispute settlement activity. For that, perhaps a secretariat or something similar to secretariat will be very helpful. Let me stop here. Thank you. Thank you very much.
Thank you. Thank you, Jamie, for highlighting a few interesting but important features of the RCEP, especially with regard to investment dispute settlement. So talking about dispute settlement, we do have our final speaker. We have Qian. She'll discuss the dispute settlement. So Qian, the floor is yours.
Thank you very much, and it's a pleasure and honor to be here today. And I've learned quite a bit from my co-panelists already, and much of what has been covered already has touched upon the issue of dispute settlement. And this is obvious in a way, and because it's absent from RCEP, and its absence, as expressly mentioned in Article 10, is what I think makes it of great interest to a dispute settlement person. And so the fact that it's expressly absent and the fact that it is part of the work program to go forward in the next 2 years to continue to negotiate this point raises a few questions. And the first question, of course, is why is this? Why has it been left absent? And I think part of the reason is that we are in an era where ISDS is proving to be quite controversial in our world, and it's worth exploring a bit as to how we got there and what got us to the point that ISDS has been concluded without, that RCEP has been concluded without an ISDS for now. Indeed, the RCEP negotiations themselves have stalled in the past almost decade, partly due to this very provision, or the fact or the question as to whether such a mechanism should be incorporated into this mega FTA. Now, certain countries, including Malaysia, India, Indonesia, and New Zealand, have expressly and officially opposed the inclusion of the ISDS mechanism, and others were as well in the end. And so, of course, this treaty was concluded without. Now, as has been mentioned by other speakers, there is furthermore the closure of any loophole of the applicability of clauses to ISDS mechanisms and other investment agreements. However, what this does not preclude is the investor from what this means is ultimately that corporations do not have an avenue for recourse or ISDS protections by way of RCEP. However, as also mentioned, Chapter 19 provides a mechanism for the time being that is similar to the WTO dispute settlement mechanism, allowing one party to bring action by way of a party state or a member state. In effect, what this means is that a party to RCEP that commits a breach of its obligations under the RCEP investment chapter may be faced with a claim not by the investor, but rather by the home state of that investor. Now then, the home state could then bring a claim against the host state under Article 19.3 of RCEP. The reality of this protection, of course, is that it's not without certain carve-outs. Specifically, Article 17.11 of RCEP carves out a major area of protection by providing that RCEP dispute settlement mechanism is not applicable to disputes relating to pre-establishment rights, as has been mentioned by other speakers. RCEP further provides that state parties with a choice of dispute settlement mechanisms, specifically from other mechanisms found in other investment treaties, could be made available. Now, what I want to spend some time in doing during my remaining minutes is rather than touch on the policy aspect, but rather go through what does exist as it stands under RCEP. I have mentioned primarily the dispute settlement mechanism is state to state, and that is found in Chapter 19. In a way, it is inspired by the WTO dispute settlement mechanism. It's not entirely the same, but it is similar and has drawn inspiration from the WTO settlement mechanism. Pursuant to Chapter 19, parties to the dispute may at any time agree to an alternative dispute settlement mechanism, including conciliation or mediation. In short, there are a few specific steps that are taken by states when engaging under the existing dispute settlement mechanism, and that is consultation, the request for the establishment of a panel, the establishment of a panel itself, and of course then the proceedings, and then the issuance of a report, the implementation, and then there is a potential opportunity for a review or a compliance review, and then ultimately the possibility of compensation or suspension of concessions or obligations. Now, going through a bit more as to the mechanisms associated with the existing dispute settlement mechanism that exists for state to state or party to party within RCEP, the appointing panel, the appointment of a panel or an RCEP panel is very similar to other dispute settlement mechanisms, whereby there is a panel of 3 members unless the parties agree otherwise. And And furthermore, similar to the appointment of arbitrators under most institutional rules, there is the opportunity for each of the parties or each of the states to appoint their own arbitrator, whereby these co-arbitrators then appoint or agree upon by list procedure or otherwise to a chair. If the parties can't agree, then of course there is the designation of an appointing authority. And in this case, it would be the Director General of the WTO, failing which it would fall then to the Secretary General of the Permanent Court of Arbitration. Now this is a system that exists, or at least the structure or the process of appointment is one that exists under most ISDS mechanisms. The nuance being that the designated appointing authority first falls to the WTO, as it is inspired by that, and then the second option would then be the PCA. Now the panelists do have certain qualifications, and now this is a growing trend, I think, in terms of designating or detailing the factors and the characteristics of who might qualify as an appointing authority, as a member of the tribunal. In this particular case, there is no specific expertise necessarily, but rather there is a strong emphasis on the neutrality and the importance of impartiality of the chair and the party at the tribunal. In this case, again, with impartiality, oftentimes the nationality of the tribunal members will be regulated. In this particular case, there is a express stipulation that the chair shall not be the nationality of any party to the dispute, or the third party should not have the residence in any of the parties to the disputes. The additional characteristic or qualification that is necessary is that the chair should have served on the WTO panel or the WTO appellate body. And this again reflects the inspiration of this existing mechanism to the WTO procedures. Now, in terms of the proceedings themselves, the procedures for the proceedings are sketched out again in Article 19, but the RCEP Joint Committee is in the process of drawing up and adopting more specific procedures, namely the rules of procedures for the panel proceedings. And it is expected that this procedure should be available within the year from the date of the entry into force. And finally, in terms of the remedies available, the panel then will issue, or the tribunal members will then issue a final and binding report where any wrongdoing state is ordered to bring its measures into conformity of the RCEP or carry out its obligations under RCEP. If, however, the host state does end up refusing to comply with the order, there can be then this compliance review. So somewhat similar to, again, the WTO, but some sort of an appellate mechanism or a review process of the report. Now, this is an interesting aspect, I think, because one of the criticisms of the ISDS mechanism is indeed the fact that there is no true wholesale review process. And there are other criticisms that are brought to bear. And I think in the next 2 to 5 years, as has been indicated by the other panelists, we will see a continued negotiation of what an ISDS mechanism for investors or corporations might look like down the line. But in the meantime, there is this state-to-state dispute settlement mechanism that is available. Query how effective it will be to draw investors into this RCEP and utilize RCEP as a means or an encouragement to bring about investment if there isn't such a true enforcement mechanism. But for the time being, I think in the principle of RCEP remains a positive encouragement for the general unification of the region.
Thank you, Chian. So thank you, Chian, for the insights on the dispute settlement and RCEP. So with that, we have already had 5 excellent presentations from different aspects of RCEP and impacts of RCEP. While we are still collecting more questions, and some of the questions have already been answered by our speakers. We are waiting for probably a bit more questions. But before that, I do have a common question for each of the speakers, and that is how the RCEP would impact on the trade rulemaking at the global level, especially if we consider the situation that there is a kind of fragmentation of investment and trade treaties nowadays. Now we have another one, which is a mega one, and probably the biggest one, at least in terms of population and probably GDP as well. So how will this change or impact the global trade rule making? More competition, more compromise, or whatever. So I would like to know your insights in that. So should we follow the original order? So Liz, do you mind taking the lead? Please.
Thank you very much for that question. It's very interesting because, Singapore, like many of the other countries who've got quite a lot of FTAs, always said that the FTAs are a building block to how you can bring back new rules or modernize the multilateral rules, because the FTAs are usually faster to negotiate. So what do you bring back to the multilateral system? Unfortunately, over the last 20 years, since most of the FTA strategies have started, for a myriad of reasons, we haven't really seen anything really going back. Instead, what we saw in TPP and to some extent even in RCEP is that issues that the FTA parties were pushing at the multilateral because they were stuck, then come to the FTA and then get harvested there. But I think the colleagues earlier maybe pointing out about the investment facilitation, that is an ongoing joint statement initiative at the WTO. So there you could see maybe that sets the scene, especially since the co-lead of that discussion at the WTO is an RCEP member. So you can see some synergies there. So it depends as to how we all work together and what the coalition of the willing at the WTO is willing to move forward, or do they think, as nowadays, unfortunately, you see this, is that I'm very happy that if it's just me and my close partners that are having these modern rules. I don't really want to add on to competition by bringing it to the wider fold. So it is something just to monitor and see, but over time, I would say.
Okay, thank you. Thank you, Liz. So Mia, do you have something to say on this?
I will just add to maybe in different words, but mostly what Liz said is that, we have to look at the global trade rules and how they are made, and are they made at all? Because we haven't seen really much of the rulemaking at the global level, as just said by Liz. And the reason for that, the reasons are many, right? And so when we look at the contribution of RCEP or similar agreements, then it will be really understanding that the global system will then perhaps have to deal with accepting this plurilateral, like-minded or coalitions of the willing rules making, but trying to keep it or trying to make it possible to multilateralize for the impacts, right? Rather than keep it as closed, because now you have obviously the only thing that we had under WTO global trade system was trade facilitation, which is not a standard rule making things, and it moved because it was really looking at combining together capacity building and flexibility, and because it is facilitating. And I think investment facilitation has good chance to actually get some traction in that context. I don't know what will happen with the other similar plurilateral. I'm hearing that the environment is getting some sort of a second chance in life, etc. I don't know, but I think if we accept that there will be changes in the global rulemaking, then I can see how RCEP or similar will actually contribute to these setting new rules, not the old rules. But the question is, how many of the old rules do we actually need? And I think in particular, perhaps we haven't talked a lot about e-commerce or what it means for the rules in digital economy, and I think this is where we really need a champion, because just dropping the charging tariffs on electronic transactions or transmissions is not sufficient. We really need to start addressing more of the other regulatory issues there. So if RCEP manages to make some contributions there, I think it will be very, very welcome. So let me stop there, because probably people can say much more on that than me.
Thank you, Mia. Thank you. Haiyan, please.
Thank you very much, Man Jiao, for asking that interesting question of fragmentation of investment rules. What is remarkable in RCEP related to this point is I see its most favored nation clause as an effort of multilateralization for substantive issues, but not procedural issues. But that multilateralization of investment protection rules is possible through the MFN clause only for 11 state parties, namely Australia, Brunei, China, Indonesia, Japan, South Korea, Malaysia, New Zealand, Philippines, Singapore, and Thailand, and not the other 4 countries as I mentioned before. And that is of significant importance if and only if there is an investor-state dispute settlement. Again, my point on no enforcement or supervision mechanism created for investors, which traditionally can be found in other international investment agreements, makes RCEP very much less appealing to be relied by investors. I'm wondering whether Chapter 19 on state-to-state dispute settlement will be of much use if they can, if investors can invoke other applicable bilateral investment treaties and treaties with investment provisions dispute settlement mechanism, and also their protection, which more favorable for investors. And then, however, multilateralization of investment protection rules is not the case for 4 other states, Cambodia, Laos, Myanmar, and Vietnam, because they opt out of MN clause. So still, I think it's a positive step towards the multilateralization of investment rules, but we have to wait and see, because it all depends on the enforcement mechanism which investors can use and control. Thank you.
Thank you. Jamie, do you have something to add, please?
Thank you, Cliff. Thank you. I'd like to underscore the importance of RCEP. At this particular time, we are now seeing the faltering, the global multilateral regime, and the paralysis of WTO dispute settlement mechanism. I think at this juncture, the decision of the 15 states itself is very important for many reasons. So I think for political implication and a symbolic nature, the conclusion of RCEP is very important. And specifically in terms of rulemaking, I think the 15 states have taken important stride. Indeed, there are areas of improvement. Indeed, I would expect a wider stride in many new areas. But at the same time, we have to understand the reality. We have 15 states who have a wide spectrum in terms of economic development. If we understand the reality, perhaps the 15 states had to find some compromising ground, considering that perhaps the landing zones would have been the result of the new rules that we are seeing now for the RCEP. So there are areas of improvement, but given that, still, this is an important achievement. And as we always say, the perfect should not be the enemy of good. So we can try and we can improve, but the fact itself is important for now. Thank you.
Thank you. Thank you, Jamie. So Chian, please.
Yeah. Thank you. There's not much more for me to add on what my colleagues have said, but I just wanted to kind of take the more macro perspective and the symbolic effort of this result of this RCEP. I mean, this mega treaty was concluded during COVID, of course, and it took place over almost 10 years of negotiation, and in the context where, you know, the TPP and CPTPP and the involvement of the US was in play, and there was big talk about the TPP over the years, and RCEP was the regional stepchild, and in fact, at the end of the day, this regional stepchild came to the fore, and obviously there are there is quite a bit of unfinished business, but the fact that 30% of the world economy, the global economy, is represented under this treaty, I think is a symbolic moment for the strength of Asia and how it can operate independent of the Western economies.
Thank you. Thank you, Chian. So we have a first round of questions. I think very, very heated and interesting discussions. And we're fortunate to still have a few minutes to pick up some questions from the Q&A box. So let me, some of these questions have already been answered, but there are a few left. The first one I would like to pick is a very interesting question, probably not a very legal one. So will India rejoin the RCEP in the future? India was part of the negotiation, and then it decided to leave at the very end of the negotiation. So will there be any possibility that India will rejoin the RCEP? Well, the question is not directed to any specific speaker, but let me take the liberty to ask Liz. I think it's probably more about the making. So do you have something to respond?
I think all 15 parties hope India will come back. There's a lot of India-specific provisions in the RCEP chapters, which India had pushed for and others had agreed to. So there's a lot in there for India as well. So as I said earlier, I think, domestic fears because he didn't get a clear majority in the elections, and therefore was he there going to be selling out the farmers, and it's because of the perceived competition coming. So to me personally, if Modi can start to reassure and work with the confederate industry in India and stuff like that to say how actually being part of RCEP will boost India's economy rather than being out of it, we all hope that India will come back, and we have kept the door open for India. So, the understanding is that India, if they come back, they will not come back as an exceeding country where they have to renegotiate everything, but they can just, sort of like step in, except maybe for some of the, newer issues, if they take a very long time, and if ISDS or is something like that in which is rulemaking or market access, then maybe. But otherwise, the door has been kept open because we work so hard. I mean, I was chair of the IP working group, and there's so much in the IP chapter which was India's offensive interest, things which a lot of the other parties have not had in their other IP chapters in FTAs like GRTK and traditional knowledge. So it would be a pity after all that if India never comes back.
Thank you, Liz. Anyone else? Any of our speakers would add on that? Okay, so if no more, I do have another question. I think the question is the very first one, which is about the possible effect of RCEP on non-members, especially least developed countries and small states. I understand not necessarily in this region, but in the Asian Pacific region, we do have a number of least developed countries and quite a lot of developing countries. Some of them are now members of RCEP. Many are not. Given as you all have mentioned that these countries are adjacent countries, and what effect will RCEP have on these non-member states? So anyone would have any thoughts on that? Probably I would, yeah, Mia, please.
Well, I think it was part of what I was going to talk, but then ran out of time. Now, interestingly enough, these other least developed countries or the lower income countries in Asia have not had any agreements with any of the RCEP members, right? So now the direct impact, therefore, will not be that huge because they are also not having very intensive trade with the RCEP countries, right? So when you look at the map of the agreements and the map of the trade flows, the poorer countries are having very clear trade relationship with the large neighboring country. So you have, for example, Nepal, Bhutan, depending on India, all right, or in particular on imports, right? But then on export side, you have countries like Bangladesh that export to the countries of European Union and United States, right? And import stuff from Asia. So obviously, there will be some trade diversion with some of the countries being able to find their space in that. But so far, the modeling that has been applied was not really looking very specifically in the direction of the impacts on these countries, right? So probably in the longer term, if they are left out and if they don't join RCEP, there will be there could be some consequences, right? Because not so much direct trade flows, but losing the large market size with new rules that will give them the opportunity to develop new industries and being able to develop new competitiveness through that. Thank you.
Okay. Yeah, thank you, Mia. Anyone else would like to add on that? So it's a very broadly themed question. So, but otherwise, let me try to stop here. Thank you all for the excellent presentation and the discussions. So now I would like to invite our co-chair, Professor Wisha Gu from Hong Kong University, to give a closing remark. So Wisha, the floor is yours.
Thank you very much, Manja. I learned a lot myself as well. So thank you so much for our knowledgeable panelists. And then thank you for sharing with us about the very important and valuable 1.5 hours. So I would also like to thank the audience. I saw very enthusiastic Q&A interaction in the chat boxes. So I would like to make some sort of announcements on behalf of the Asia Pacific IG interest group of ASO. First, we are having a webinar series, and then many of you have learned that we launched that last year. We will have more webinars, very exciting webinars focusing on topical issues unfolding this year. So please do stay tuned, and then please do keep your eye on this space. Also, please stay tuned with the newsletter, and then we're very fortunate to have Ms. Chen Pao, our very knowledgeable co-panelist today with us. And then in particular, we are going to have a RCEP RCEP feature edition in the newsletter that will be coming out in the next issue. So very exciting movements in this Asia Pacific IG section. So I would like to invite all of you to keep an eye on this space, and then thank you very much, Manjot. Back to you.
So thank you, Wisha. Actually, I have no further things to add. My last word would great thanks to all our speakers. Thank you for joining us from different parts of the world. It's very late in some parts, and a great thanks to all our audience. We have a great audience, and the session will be recorded and then videoed in through, I think, YouTube and other channels in ASO. So if you miss this live, and you can still have the information. So with that, I would like to thank all of you, and thank you.